And then this is Mr. Coleman Fontinet. Good morning, sir. You Kaden Fontinet? And will your client waive the formal reading of the indictment?
All right, viewers, here's where it all begins. The formal reading of an indictment is basically the courtroom equivalent of opening night. It sets the stakes, one wrong move now, and the defendant could be facing serious time. Buckle up.
Mr. Fontenot, in cause number 25 DCCR 1759, you're charged with the first-degree felony offense of aggravated robbery from October 10th of 2025. And how do you plead to that charge?
Guilty.
And are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because...
Hoa, he says it's not. That hesitation is huge. Judges watch every word. A plea has to be voluntary, and any hint of doubt could trigger a full hearing on competency or coercion. This is tension, folks, real tension.
what they charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas? Do you fully understand them? And it looks like there is no agreement in this case. But y'all marked out one thing, but then signed it that. So the post-conviction waivers, y'all marked out. But on the admonishment, you put that it's a plea bargain and he has a right to appeal. So if it's unagreed, he has a right to appeal. So I'm going to need you guys to sign, you and the defendant to sign that bottom, please. Would you do me a huge favor and put this in the microwave for 30 seconds? Maybe even a minute. It's so cold in here. It's kind of cold. Thanks. So it looks like there's no agreement, which means you're leaving your punishment up to me. And that range of punishment is a minimum 5 years up to 99 years or life in prison. Do you understand? What'll happen is, if I go forward today, I'll go through this plea and then I'll reset your case for sentencing. The probation department will do a pre-sentence report, and then at sentencing, Mr. Coleman, Mr. Rojas can put on any information or evidence that they want, and then I'll make that decision. Do you understand? You have an absolute right to have a jury come in and determine 2 things. First, you can...
Here's the kicker. No plea deal means the judge holds all the cards. Minimum 5, maximum 99, or life. That's not just a number, it's the full swing of the hammer. The defendant is literally trusting the judge's discretion. High stakes, high drama.
Have them determine if you're guilty or not. And then if they find you guilty, you could leave your punishment up to that jury. If we go forward this way, you're waiving that right, and is that what you want to do? Do you want a jury, or do you want me? Okay, so you're waiving your right to a jury, right? Okay. Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Fontenot...
Notice the legal triple threat here: jury rights, plea consequences, and potential immigration fallout. One slip, and this could affect freedom, future, and even citizenship status. Every lawyer wants their client to understand this fully. It's not just paperwork, it's life-altering.
That is not competent.
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing. Like I said, we'll get that pre-sentence report done, and then we will come back later for sentencing. Anything that you think is important for me to know, get that information to Mr. Rojas, and he'll present it to me on your behalf when we come back. Do either of you anticipate a long hearing or just a normal day? We should be fine. Okay, we'll see y'all back at sentencing. Mr. Fontinet, I don't know that we checked today or not. I just want to let you know something real quick. But for sentencings, we always get jail incident reports. So I don't know what you've been doing, hopefully nothing. But if you have been acting up and getting incident reports in our jail, it better stop today. Because I'll look at all of them, and if there's reports, when you come back, it is very unlikely that you're going to get a whole lot of anything out of me as far as low end of the punishment range or probation or things like that if you can't follow the rules out there, okay? Okay, we'll see you back at sentencing. Good morning, are you Dominique Lee?
Classic judge mic drop moment. Behavior behind bars can directly influence sentencing. Even before the next hearing, the defendant is under scrutiny. This isn't just about past crimes, it's a warning shot for future conduct.
And this is 25 DCCR 1784. Mr. Lee is charged with criminal mischief from October 14th of 2025. What is the announcement?
Judge, I've talked to Mr. Lee about the situation. I've also, of course, have talked with the state. There is some information I do need to check out in regards to probation he had been recently placed on, and some other things with his criminal history. Because especially with that probation, I think that may give us an option to try to get this resolved.
A probation here or somewhere else?
That's
Here.
here, Judge. And we spoke about this, but I mean, he's got obviously through the indictment, it's like it bumps it up to a third degree versus what his
Bumps it up to a second.
Second, actually.
But if there's do you show an active? So there would be an MTRP if there was.
I don't have.
All right, I'll reset it so you can figure that out. Because if there is a motion, I would assume that there would be a motion to. I mean, if there is a probation, I would assume there would be a motion to revoke. So I'll just do a normal reset to give you some time to get all that worked out. If you'll check into it
I'll
too
check
and
into it.
see.
I did check prior to coming down, Judge, but I don't have that. It's not in our system. So
Okay.
I'm not sure.
Talk to probation, talk to him more, and see if you can figure it out. Otherwise, we'll go forward with what we got when we come back.
Because my understanding is that is kind of what led us, because he was in custody at the time and then was released when he received the probation. This allegation occurred, of course, inside the jail.
The criminal mischief?
Yeah, this occurred while in custody.
Okay.
So.
Okay. Okay, I'll let you guys check on it and see what it was, and if you got the probation after the incident. It's okay. All right, we'll figure it out. Y'all figure it out. Okay, go back with the bailiff. Thank you. All right, you're Andre Williams. And so Mr. Williams' case is set for trial to begin with jury selection Monday. Announcements?
Judge, I've talked to Mr. Nichols. I'm asking for 30 days. I finally got some clarification on the Social Security records that I'm trying to obtain. They told me how to do it. They'll either let me know they're ready, I send them an invoice, if they'll give them to me. They'll certify them, they'll make them court admissible.
And here we pivot to the classic trial prep grind. Delays for records, subpoenas, and certifying evidence. Most of the courtroom drama isn't action-packed but is crucial chess moves behind the scenes. Think of it as legal suspense, slower but just as strategic.
It doesn't have to, nothing about an order from this court or a writ or anything like that. They told me it may take up to 90 days, and that was 60 days ago when I think I finally got on the right track with them. So I'll know something, if I don't have them then I just...
I mean, and you believe that they're necessary for the trial?
I think, like as the court pointed out last time, they may be necessary in mitigating circumstances.
Mr. Nichols?
Mr. Vasquez has kept me up to date on his efforts there, Judge. We've discussed trying to resolve the case as quickly as we can.
And I guess would the state at trial be going on the murder?
Yes, Your Honor, that's my intent.
Okay. Is that, I don't want to wait for all of this
No, Judge.
for mitigation on a murder if you elect to go on
No,
the other.
we're going forward on the murder.
Okay. All right. So I will reset. It will be on the next trial docket, which should be more than enough time. That's about 75 to 90 days-ish for our trial dockets. And then at that point, it'll be time. It's getting old, and it'll be time to get the case taken care of. Okay? All right. And as always, I've said, if you need any help, let me know.
Thank you, Judge.
All right. Thank you.
Thank you, Your
You
Honor.
can go back with the bailiff.
Where facts meet emotion, justice finds its voice. To witness more real courtroom moments, subscribe to Law Next.
Remember folks, each plea, each objection, each motion tells a story about the system and the people caught in it. Keep watching, because behind every transcript is a life hanging in the balance.